Hi guys, I'm Sava, and I will be backing up my opponent's claims on the Patriot Act. And also I will be talking about my opponent's claims about roving wiretaps and how it doesn't really affect innocent people. I have certain examples of how it does. Well, let me start off by saying our proposition is that the Patriot Act should be modified to reduce the power of the government. We have claims that the current policy is inadequate because it violates people's privacy. Also, the current policy is flawed because of the government's misinterpretation of the powers offered by the Patriot Act. And also, the Patriot Act should be revised to regulate the government's abuse of information sharing. And we're covering three main aspects of the Patriot Act. The authority to share criminal information, roving surveillance authority, and access to wire and electronic communication. So let me start off with our first claim. The current policy is inadequate because it violates people's privacy. What I mean by this is that the Patriot Act violates an individual's First and Fourth Amendment rights. I have an example of the U.S. District Court judge. His name is Victor Marrero, and he helped the American Civil Liberties Union by ruling that parts of the Patriot Act violated the First Amendment. He said when the judiciary lowers its guard on the Constitution, it opens the door to far-reaching invasions of liberty. And he also ruled that national security letters, which are a search procedure, they violate the Constitution because they amount to unreasonable search and seizure. Also, according to Michael German and Michelle Richardson, these are both council members of the American Civil Liberties Union. The Patriot Act vastly and unconstitutionally expanded the government's authority to pry into people's private lives with little or no evidence of wrongdoing. This overboard authority unnecessarily and improperly infringes on Fourth Amendment protections against unreasonable searches and seizures, and also First Amendment protections of free speech and association. I have an example of a court case, Doe versus McCasey, that the FBI asked for a national security letter, which is a search procedure from an internet service provider. And they demanded customer records, but they asked the internet service provider not to tell that the FBI asked for their evidence. Under the 2005 revisions of the Patriot Act, this was allowed, but the District Court of New York ruled that the provisions violated the First Amendment and principle of separation of powers. Furthermore, Section 218 of the Patriot Act, it eliminated the requirement that the primary purpose of a search or surveillance must be to gather foreign intelligence. Well, the Patriot Act, now they let the government to search for only a significant purpose. I have an example of Brandon Mayfield. He's an American attorney, and he was subject to surveillance searches from the FBI. Here's a good example of how innocent people are affected by roving wiretaps. The FBI searched his home without his notice and discovered they had mistaken their suspicions on him. And he responded, in the debate over the scope of the government's authority to wiretap Americans, we often hear people say, if you're not doing something wrong, you have nothing to worry about. And he says that I'm here to tell you that even the innocent can have their lives turned upside down when laws designed to protect against unrestrained government's actions are weakened. My second inherency claim is that the current policy is flawed because of the government's misinterpretation of the powers offered. What I mean is that the government and the FBI are misusing their new given powers, straying away from what they were intended for, such as terrorism investigations, and they use the powers for their own benefit. For example, secret searches and demand for library and medical records, sections 203 and 215 of the Patriot Act, are violations of civil liberties because the government has overstepped their boundaries. The sneak and peek provision lets the government search a person's home and delay telling them about it. This breaks tradition that government should announce when they enter, and the law clearly goes too far. And it should be used in case of terrorism cases only. Also, my opponent claims that the government targets specific people related with terrorism, but actually little is known about the government's use of its many authorities under the Patriot Act, according to the ACLU. Statistics show that there's skyrocketing numbers of national security letters and suspicious activity reports, but terrorism prosecution numbers are down, and the declinations to prosecute FBI terrorism investigations have increased. Data produced by the Executive Office for United States Attorneys show that FBI terrorism cases dropped from 2002 to 2008. So the government and the FBI are given these extended powers, but they're not putting forth the causes intended for. Also, according to the ACLU, in 2006, the Department of Justice declined to prosecute 87% of the international affairs and cases the FBI referred for prosecution. Farhana Kara, who she's a writer for CNN, she wrote in her Reform the Un-American Patriot Act that according to one former senior FBI counterterrorism official, the FBI conducted nearly 500,000 interviews of Muslim and Arab males from 2001 to 2005, and not a single one of those interviews led to information that would have allowed the government to detect or prevent 9/11 attacks. Also, laws prohibiting using material to support terrorism is in desperate need for a reevaluation reform because Section 805 and 10 do not require the government to prove that the person they want to investigate is directly involved with terrorism. And, an example of this is when the FBI took under surveillance a peace and tolerance organization. This is in response to my opponent's claims that innocent people aren't really targeted. Wanda Guthrie, she is a volunteer for the Thomas Merton Center for Peace and Justice, and she responded for the FBI to monitor us as if we were terrorists it's illogical. And my last claim is the Patriot Act should be revised to regulate the government's abuse of information sharing. For example, national security letters and Section 215, you should repeal them because it allows the FBI to demand information about innocent people who are not the targets of any investigation. And Congress, not only should they be careful of the Patriot Act powers, but they should review other laws. My opponent claims that if you are under surveillance, it's because you must have triggered the government. Well, an example of this is a student, his name is Konstantin Ordaninsky. He goes to UC Santa Cruz, and he participated in a Student Against Wars campaign. And he responds, and he was surprised to find out that he was in a Pentagon domestic threat database. And he says that the government believes that the peaceful protest in which I took part is a credible threat when lawfully standing up for my beliefs, standing up for what I think is right and just is a threat to the government, something is wrong. And that's it. Thank you.